All rise.
Hearing the test claimants appeals.
Yes, Mr. Ewart.
Good morning, my lord. I was going to start by taking you back to In re Diplock and to answer the question that my Lord Sales asked about that particular sentence in the judgment of Lord Green.
Yes.
I'm afraid the answer is slightly complex.
That was,
It's 10:30, not 3 o'clock in the afternoon. So.
yes, that's in volume
Sorry,
7.
which was the sentence we're casting light upon?
It was.
Volume 7.
And what was my
97.
question?
I think your question was that there was a suggestion that there was prior to the 1939 Act a position where mistake of law was relevant. It was
So where are we looking
the
at?
passage that you were referring to. I think was in 480, page 480. Sorry, it's volume 7 of the authorities,
MS.
tab 97, and it's MS 2886. And it's a sentence. Unfortunately, there aren't any numbers or anything to guide you, but it's about a quarter of the way up from the bottom. It's no doubt true that for certain purposes, for example, the purposes of application of the statute of limitation, the direct equitable claim of the unpaid beneficiary against the wrongly or overpaid recipient of part of the testator's estate has hitherto been regarded as analogous to the common law claim for money had and received. It was that sentence I think you were questioning. And the answer is actually in this case, but you do have to look very carefully.
I think that the point that I was making was that until Reed Diplock put the matter straight, it was being assumed that the position as between the persons who received money under the will, the wrong legatees and the right legatees, was the same as between the executors and legatees.
Yes.
And that there was essentially a correspondence between the equitable position and the common law position, i.e. no mistake of law.
Yeah. Now, the position is rather more complex than that.
All right.
I was going to explain it to you. Can I take you to page 508, which is MS 2914? I think this is the best starting point. And there you can see at the bottom, they set out section 20 of the 1939 Act. This is a new provision that was introduced in 1939. It provided for a limitation period of 12 years for an action by a beneficiary against a trustee where the trustee has been party to the fraud or trust property. It says no action in respect of any claim to the personal estate of a deceased person or to any share or interest of such estate, whether under a will and testament, shall be brought after the expiration of 12 years. Now, what the Court of Appeal decided in Re Diplock was that provision applied to direct claims by one beneficiary against another beneficiary. And that was because of the words in respect of. That they were wide enough, they held. So that was the limitation provision that applied in this case. That was what the Court of Appeal held. Now, the history was this. Before 1939, there were provisions relating to recovering trust property that had been paid wrongly, but they only applied to actions by the beneficiary, the disappointed beneficiary, against the executors. And that was because they were slightly differently worded. And there was a lot of discussion in Re Diplock about the difference in wording and whether that makes a difference. And the Court of Appeal concluded it did. So the problem which arose before that, and had arisen for decades or centuries, was what is the limitation period in respect of a claim by a disappointed beneficiary directly against another beneficiary who had been paid out? And what the courts decided, possibly often by almost concession, but they decided anyway that it was by analogy with the limitation period for claims for money hadn't received based on mistake under the statute of James I. That's one of the statutes that is mentioned in the report. If you remember, they list the number of what are the limitation provisions in force before the 1939 Act. And one of them, quite an important provision still, was, I think it was 1623 or something like that. It was the Statute of James, which provided primary limitation periods. Now, that statute provided a 6-year limitation period for those claims. And what the courts of equity had decided was that they would apply that by analogy to these type of claims.
That's what equity generally did in relation to equitable claims before they were...
It tried to find something
Yeah.
and applied it by analogy.
Not as a statutory exercise, but as an
No.
equitable exercise.
Precisely, yes. So the statute didn't apply to these claims. The Statute of James didn't apply, the other provision didn't apply, but they found this by analogy. What Lord Green was saying in this case was, first of all, in the passage we looked at it, I think it was 480, that was completely wrong. These were not in any sense claims of that kind, for two reasons. One, there was no mistake by the claimant, and secondly, there was no payment by the claimant. The payment was made by the executors, and so they were simply not in that class at all. What they decided was the 1939 Act provided a limitation period in Section 20 for those. But this was not a claim based on mistake. This was a claim based on the fact that the money which belonged in equity, essentially, to the beneficiary had been paid to somebody else.
I mean, it wouldn't matter whether it was by mistake or deliberately, would it?
It wouldn't matter at all. And one of the other points that's made in this case is that the period when the limitation period began is different from the period that would begin in a payment by mistake. In the payment by mistake case, it would be when the payment was made. In this action, the limitation period began on the date on which the beneficiary was entitled to a distribution from the estate, which could be after, of course, the payments were made. The time when the administration was complete and the beneficiary was entitled to the distribution, that's the point at which he had a right in equity to recover the money that ought to have been paid to him. So that's the date they said the limitation period ran from. And all of this shows that it's a very different action from an action for money hadn't received based on a mistake. And all of that is explained in the pages between 508 and 514. It gets a bit complicated because there are various acts brought in and amended and whatever. That's why he goes through the whole history of it here. But that is basically my other position.
Yeah, thank you very much.
Yeah, which I think supports the view that in 1939, well, what Lord Green has decided is that, as a matter of construction, the Act of 1939 provided a limitation period for this very claim, specifically.
And that was the beneficiary to beneficiary personal claim, was it?
Yes.
Yeah, not the proprietary. If there was one. Not the tracing claim.
It was a claim based on, in a sense, proprietary.
Yes, but it was a personal claim.
It was a personal claim,
Yeah.
The other thing, of course, is they only had the claim to the extent that their claim against the executor was exhausted. It's another point that's made in Rediplock. So they could only claim the balance. They had to claim from the executor first, in a sense. But once the executor's resources had run out, they could claim the balance from the recipient beneficiary. And what Mr. Upjohn had been arguing was Section 20 didn't apply. You can see that at the top of page 509. He was arguing Section 20 didn't apply in the same way that the previous provisions hadn't applied to direct claims. And he was arguing you still carry on with the analogy, the limitation period by analogy, the 6-year period. And that's what the court was rejecting as a matter of construction of the 1939 Act. They held that Section 20 did apply to these claims. That's why I said all of what they said about analogy, etc., was entirely obiter. It was on the basis that they were wrong about that. And what they were saying was, even if we're wrong about that, and you could rely on the analogy, you now have to take it along with the extension period, which has now been introduced into the 1939 Act. So before 1939, there wasn't this extension. So you would say that the period was 6 years, full stop. After 1939, if you were saying by analogy what Lord Green was saying, well, even if that's right, which we say is wrong, you can't win, because you have to take it along with the extension of what is now 32(1)(c), and that would bring them within time. They were out of time if it was 6 years, they were in time if it was 12 years, or if it was 6 years extended from the time when they could have discovered it, which I think was partly based on the fact they couldn't have discovered it until the testator died, or something like that. Sorry, when they discovered the testator had died. So that's re-diplock. We've also...
that all takes us back to Lord Gough.
Yes, which I was going to...
Time Warden. What you're saying is his reliance on diplock was unfortunately mistaken.
Mistaken, yes. I have to make it clear, and we're just going to go on to look very briefly at what's said about updating construction. I'm not saying that this is conclusive of the point by any means. I'm simply saying it shows that it's not an answer to the argument that 32(1)(c) doesn't apply to mistakes of law. It's not an answer, as seemed to be thought in Claimant Benson, that the history shows that there were such claims and that the Limitation Act applied to them. I'm saying the starting point is there weren't such claims.
Yeah, but it's a passage at MS 525, 526, where he relies on diplock, and you say that's unfortunately mistaken. Yeah. Okay.
Yes.
Can I just be quite clear what you're saying? I think you're saying there was, in 1939, no equitable money claim based on mistake of law.
Yes.
Yeah.
Or either in equity or at law. Obviously.
Well, yes, but for present purposes, we're looking at Lord Gough's analysis, so we're mainly looking at equity.
Yeah. Yes, exactly. Yeah. So we have provided you with a small bundle of materials on updating construction. And I don't think, I wouldn't be suggesting that this act is one of these rare acts that Benyon refers to, which is intended to be of unchanging effect. I'm not sure what the examples of that are, but anyway, I'm not saying that's the position. The question really is if you look at section 288, which is on the first page of the bundle, Benyon sets out the code for this. And it's really 6 I'm looking at. Nothing in the foregoing subsections justifies a construction which alters the meaning of the words used in the enactment in ways which do not fall within the principles originally envisaged by the enactment. And that's why I was relying, yesterday I was making the point that the policy of the Limitation Act generally is that limitation periods are not postponed until the claimant understands the legal consequences of the facts, but rather when he has knowledge of the facts. And I was going to take you briefly to a case about that, which is in the new bundle. It's a case called Malloy, which is at tab 10 in the bundle of authorities, supplementary bundle.
And the 1980 Act was a consolidation statute, wasn't it?
It was, yes.
And the 1939 Act also, I think, was a consolidation statute.
To some extent, although it did introduce new provisions.
Was Section 26 one of the new provisions?
I think, yes, it would be, yes. Because I don't think there was a statutory provision of that sort before. Yes, that's right. Because the point about the committee's report, they were suggesting that the statute should follow what had been an equitable approach in certain cases.
Yeah. Right.
So that was new. And there were other new provisions, I think, or differences. The idea was to try and rationalise a law which came from various sources going back to 1623. So Malloy, it's tab 10 in the new bundle, the authorities bundle. Sorry, Malloy, it's in the when I say the new bundle, the one which we put in yesterday or the day before.
Supplemental authority.
Supplemental authorities bundle, yes. Tab 10. Yes. I think you had it by email. I think you were able to find it yesterday.
Is it?
I'm afraid this case is, the way it's reported is rather dense because it's in the Law Times. It doesn't have very many paragraph breaks.
What are we looking for in this case?
Well, can I just tell you what happened first of all, and then I'll show you those passages. It's talking about the policy behind the limitation.
What's the proposition you're hoping to get out?
The proposition is that it's not a policy of the Limitation Acts to defer the limitation period until you understand the legal consequences
I see. Okay.
of the facts.
Thank you.
And in this case, the plaintiff took out a policy allegedly on inducements that he'd only have to pay fixed periodical premiums. However, the insurance company subsequently claimed for increases. They took a claim to the county court. The claimant defended on the basis of what he believed the construction of the policy to be, that he couldn't increase the payments, and he lost before the county court judge. The county court judge said, the contract means they can be increased. He didn't appeal that. Subsequently, another claimant took a claim which ended up in the House of Lords. The House of Lords confirmed that they were right of the construction of the policy. However, they said that there was misrepresentation, and that had the effect that you could set aside the contract and not have to pay. The plaintiff brought an action again thereafter, saying, look, I've now been told by the House of Lords that I can set aside this policy. The question was, when did the limitation period start running in relation to that? What was it when he was told, when he discovered the true facts, i.e. the terms of the policy, and the county court judge decided the case, or was it when the House of Lords told him the legal consequences of that, which were that he could set aside the policy because there had been misrepresentation? It was held by the Court of Appeal that it was the earlier date. It was the date when he discovered the facts. He ought to have, well, his limitation period began then. If he was wanting to bring a claim to rescind whatever, he had to bring it within whatever 6 years of that date.
Which was the statute being applied then?
I think, in fact, it was the Statute of James.
Yeah.
Because this case is 1906. It was. If you look at the beginning of the judgment of the Master of the Rolls, which is on page 760, top left-hand corner, Lord Collins, he sets that out at the beginning. The answer to that claim was the statute of limitations, 21 James 1, chapter 16. It's about, you see, the right of action accrued more than 6 years before the date of the writ. And so what Lord Collins said about this was on the following page, page 761 in the first column. And it's about a third of the way up in the first column, the left-hand column, beginning, and I dispute that. I do not think that the policy of the statute of limitations is that it is not to begin to run against a person until a person has satisfied himself as to the exact legal inference to be drawn from a number of facts which he has perfectly ascertained. The policy of the statute of limitations is based on the old maxim, expeditit re publicae ut sit finis lutium. Therefore, the object of it was really to put an end to actions after a lapse of time. And where a person knows the facts relating to his case, everybody being presumed to know the law, is presumed to know all those limitations which arise to him by reason of knowing the facts. Therefore, in the first instance, it seems to me that the plaintiff knew the facts, and knowing the facts, even although he was not able from his education attainments to draw the proper legal inferences from them, the statute of limitations was not prevented from running. Then another very great difficulty, I think, involved in the contention of the plaintiff is that really his view would involve the superaddition to the statute of limitations of such an interval as would elapse between the decision of the first court properly constituted and the decision of the ultimate court of appeal, if it was taken to the House of Lords, because wherever one of the factors going to the making up of the cause of action is the construction point of law of a document, then according to the contention of the plaintiff, that construction could never be deemed to be finally ascertained until the opinion of the highest court in the realm had been given. Therefore, the statute of limitations could never be assumed to begin to run at the date of the first decision by a properly constituted tribunal, although it was given and not appealed from, which is the reference to the, in this case, the county court decision. On that argument, it would follow logically that the statute of limitations had not begun to run until such time within 6 years as anybody might, in any proceedings raising the same question, get a decision from the House of Lords on the matter. It's a bit of an echo of the present case. Lord Justice Roma said the same thing, in particular at the bottom, on page 762, on the right-hand column, in the last part of his judgment before you get to Cousins Hardy. He knew all the facts on which his claim for rescission was based. It appears to me that under these circumstances, it is impossible to say the statute of limitations had not commenced to run if he brought a common law action and ought not to be applied in equity by analogy now that he has brought an action for rescission. So I think this is another example of it being applied by analogy. It's the statute of James by analogy. I think the Master of the Rolls doesn't like the word analogy. He says somewhere in the judgment that it's just equity following the law, but I'm not sure there's any difference. And Lord Justice Cotton Hardy said the same, although he was a bit more reluctant. So that is the policy, we would say, of the statute of limitations. We would also rely on the difficulties we discussed yesterday in shoehorning mistakes of law into section 32(1)(c). It's not apposite to be referring to discovering a mistake of law with reasonable diligence. Either, if we were right about the way it operates, it has no practical effect, because you must be taken that you could have discovered your mistake with reasonable diligence of law immediately. Or it has the effect that the claimants say, which is that you have to wait until the final court of appeal have told you what the law is, which has all the problems that we've discussed. Or it depends on some factual assessment based on factors which no one has yet been able to identify.
I mean, you're in effect saying that you're deemed to know the relevant law as soon as you make the payment, and therefore there's nothing to discover. Is that the point?
Not quite.
Seems to be.
my lord. What we're saying is, given the approach that is adopted to what is meant by having knowledge or discovering something, what you have to discover is not the truth of the position. You don't have to know the law in that sense.
I know one of your positions. There seem to be a number of different positions you're taking. One is a sort of something close to Lord Brown, which is that it's not until you've got some reason to bring your case.
That is our position. No, we have only one. I think we've only one position, which is that is the correct approach. But it does lead to the consequence when you're asking the question, when could you, with reasonable diligence, have discovered it? There's no particular reason for not going back, because you could.
That's because you're deemed to know the law from the start.
Well, it's not.
What other reason is there for driving you back to square one?
The reason is that you could discover it to the requisite degree that you'd be able to bring an action.
In this case, there's no way they would have guessed in 1973 that these payments they were making were going to be held.
I don't think we need to go back to 1973, my lord, but yeah.
But anyway, but the trouble is, the problem that you have is that even if you say that Deutsche Grenfell got it all wrong, you still you find yourself in a sort of floating middle where you can't quite logically defend any particular position.
Well, precisely. That may be the reason why, a very good reason why mistakes of law are not covered.
That's another view.
That's one view.
I'm not sure. At some point, I'd like to know which is your favourite position, because it seems to be there's sort of three positions. There's the floating middle position, which is the sort of Lord Brown position. There's the driven back to square one because you're deemed to know the law, and then there's the position, the Act doesn't apply anyway. And those are all possible positions, but it's quite nice to know which one you're putting money on. The Lord Brown position, I think, as I pointed out yesterday, Lord Brown was only dealing actually with when you actually discover your mistake. He wasn't considering. Yeah, but are you abandoning Lord Brown
that
then?
Position. We say he was right in what he said about when you would discover your mistake, actually, subjectively. But he didn't go the next step to saying, well, when could you have discovered your mistake on that approach? And we would say on that approach, you could have discovered it at a much earlier time than you actually discovered it. The time you actually discovered it is no necessary guide to when you could have discovered it. Because the time you actually discovered it would depend on factors like when you decided to actually look at it. And I think the whole point about Sefton that approach is that you must be assumed to be wanting to look at it in the past. Otherwise, it becomes a subjective test. It becomes a test as to when that particular claimant actually decided to consider the matter.
It's unreal. You're saying really it's when you have a clever and ingenious enough lawyer to think up the point, and who knows when that would be.
If that was the position in the past, then it could be discovered. I think that's our position. If the law could be discovered. Otherwise, there isn't really an appropriate principled test that you can apply, apart from looking at when they actually did discover it.
This drives you back to your point that really that the whole policy of the Act doesn't really admit you to extend it to mistakes of law because they weren't.
If you feel, I think that's if you feel that isn't a way that you can go, then I think that demonstrates that the policy and structure of this provision doesn't readily apply to mistakes of law. That's right. That's where you get to. But
at some point, as I say, it'd be nice to know how you rate your various submissions, because
yes. Well, I don't think.
Anyway, no matter now.
I'm not sure it really matters from our point of view which approach you
it
take.
It does for us to know what the revenue you're putting forward. So
yes.
Anyway, I've made my point.
Well,
we know what your case, your initial case to us was, and we know that you've produced a further case in response to a suggestion by the court. Yes. So we can judge from that where the emphasis lies.
Dr. Bezic in his LQR article says that the mistake was discoverable when the respective actions were first reasonably able to be pleaded in legal proceedings. As I understand it, your primary position is that that will always be the position at the time a mistake of law is made, at least if it's a Category 3 on your classification, if it's a Category 3 case of actual mistake.
Exactly, my lord, and that's what this is, you would say. That's the way it's been pleaded. That's what this case is. Yes, precisely. Difficult issues might arise with true deemed mistakes if you have a situation where there actually was a House of Lords decision which was something overruled. That's difficult. We have dealt with that briefly in our reply, because for completeness, if you were to take the view this was a deemed mistake, or you wanted to say something wider, but we say this is not a deemed mistake case, so you don't have to wrestle with the question whether that is a mistake and how the Limitation Act would apply if it was a mistake, whether it's a mistake for the Limitation Act. Because I think
maybe in those circumstances there's not a mistake at all.
There's not a mistake at all. I think we say that, or alternatively, it might not be, whether or not it's a mistake for the purpose of the law of unjust enrichment. It's not a mistake within the Limitation Act provision. That's what, yes. With all that in mind, can I take you back then to Clement Benson to see what was said in that case?
Just before you do, in the context of your submission that all this shows that mistake of law doesn't really fit within Section 32 at all, does that have any sort of double-edged sword knockback consequence on the question whether such a claim has a limitation period at all?
Well, we say no, because we say it comes within Section 5. It's a claim.
You say
It's a
whatever
claim of
happens.
unjust enrichment,
Yeah.
which has been held to fall within Section 5. Although, again, there's a slight fiction in all of that, but it's
It might be said that that fiction is quite telling as well in terms of the policy of the Act. So I noticed Lord Green in Re Diplock observes that for a straightforward claim for money I hadn't received, say after a payment by reason of mistake of fact, doesn't fit very neatly within what is now Section 5, was then Section 2, which talks about contracts.
Yes.
It in effect says, well, it must be covered by that.
otherwise there'd be no limitation period.
Yes, in other words, that the policy of the Act is to catch causes of action and ensure that there is limitation. So that really when one's looking at what is now Section 32, one's looking at a derogation from that general principle.
Yes, yes, and it goes back to the equity courts, where, as you can see from what I was describing this morning, they had to find a limitation period somewhere, even though it wasn't particularly apposite by analogy, because otherwise there'd be no limitation. So yeah, I would agree with that. So can we then turn to what Lord Gough said? On this issue, it's MS 524. It's volume 1, tab 15, page 387 of the report. It begins. He begins though by setting out the Limitation Act provision. And then he says, the question which arises under this issue is whether the actions brought by the bank for the recovery of the ground of mistake of law or money paid to the authorities on the void interest rate swap agreements are actions for relief from the consequences of mistake within Section 32(1)(c). He points out the precursor of Section 32(1)(c) was Section 26(c) of the Limitation Act 1939, which was in the same terms. It was enacted following the 5th interim report of the Law Revision Committee, which stated that the equitable rule at times should only run under the statute of limitations from the time which the mistake was or could with reasonable diligence be discovered, did not apply to cases which fell exclusively within the cognizance of the Code of Law. Baker and Courage, having stated that the position was unsatisfactory, it recommended that in all cases when relief was sought from the consequences of the mistake, the equitable rule should prevail. The submission of the bank was that their actions for the recovery on the ground of mistake of law of money paid under void interest rate swap agreements were actions for relief from the consequences of a mistake within section 32(1)(c). Support of this submission, they relied first on re Diplock, in which the Court of Appeal stated that section 26 of the Act would operate to postpone the running of time in the case of an action at common law to recover money paid under a mistake of fact, and would likewise apply to an analogous claim in equity to recover money paid under a mistake of law. Well, you've had my submissions on that. Second, they relied on the judgment of Mr. Justice Pearson, Philip Higgins and Harper, in which he stated with reference to section 26 of the Act that the essential misquestion was whether the action was for relief from the consequences of a mistake, a familiar example of which was an action for the recovery of money paid in consequence of a mistake. Now, the problem with that is that Philip Higgins was a case about a mistake of fact. It wasn't a mistake of law case. It wasn't dealing with the question of whether mistakes of law could found an action. It was, or fall within the Limitation Act. It was dealing with the question, the very issue that your Lordship's court decided in FII, which was, did mistake have to be an element of the cause of action in order to fall within section 26? He held it did. And the Supreme Court upheld that recently in the FII case. In answer to this submission, the submission of the authority was twofold. First, they submitted there was no mistake on the part of the bank. I've already explained that I'm satisfied that indeed paid the money under a mistake of law. Second, they submitted that section 32(1)(c does not on its true construction apply to mistakes of law. In this connection, they relied in particular on the fact that the mistake of law rule was in full force in 1939 when the provision was first enacted. And they further submitted that the words of the subsection referred to a mistake being discovered showed that the legislature was referring to mistakes of fact rather than mistakes of law, of which it would not be apt to refer to such a mistake being discovered, still less discovered with reasonable diligence. So they were making the points about the structure of the Act. In my opinion, however, this verbal argument, this is regarded by Lord Gough as being a verbal argument rather than an argument of substance, found us on the fact that pre-existing equitable rule applied to all mistakes, whether they're mistakes of fact or mistakes of law. L. Beecham and Wynne and the dicta from re Diplock. And I've dealt with both of those. I recognise that the fact that section 32(1)(c is the cause of action in a case such as the present may be extended for an indefinite period of time. I realise that this consequence may not have been fully appreciated at the time when the provision was enacted, and further that the recognition of the right at common law to recover money in the ground that's paid under a mistake of law may call for legislative reform to provide for some time limit to the right of recovery in such cases. The Law Commission may think it desirable as a result of the decision in the present case to give consideration to this question. Indeed, they may think it wise to do it as a matter of urgency. And then he refers to the positions in Scotland and Germany. You might think that some of the remarks he made in that last paragraph were indicative that something had gone wrong in the conclusion that it applied to mistakes of law. But anyway, it appears that Lord Gough's answer to the arguments from the structure of the Act was simply that they had existed, but that this was a verbal argument and it existed previously. And as I submitted, that's not correct. Lord Hope also dealt with this question. It begins on MS 553, page 416, at the bottom. At the first paragraph, he makes the point that the whole purpose in this is to take advantage of the limitation period, answering my Lord Reid's question yesterday. Then he says, there's no difficulty about the language. The word mistake appears in the subsection without qualification. Well, that's true. There's nothing in the words used in it which restricts its application to a mistake of fact. The origin of the section suggests the absence of restriction was intentional. In its fifth interim report, the Law Revision Committee recommended that the equitable rule of postponement should prevail in all cases where relief was sought from the consequences of a mistake, and that time should only run from the moment when the mistake was discovered or could with reasonable diligence have been discovered. The recommendation was put into effect in section 26C of the Limitation Act. In re Diplock, the Court of Appeal said that section 26C would operate to postpone the running of time in the case of an action to recover money paid under a mistake of fact. Well, that's true, but irrelevant. And it's not, you don't need re-diplock to tell you that. That was simply the law. If he meant law rather than fact, then we would submit he was wrong. But the distinction made between fact and law as a ground of recovery is not absolute. Relief is available where the mistake of law relates to private rights, L. Beecham. Private agreements made under a mistake of law may be set aside, and relief will be given in respect of payments made under such agreements. As I say, I've dealt with that. Other examples may be given where a cause of action for relief will be available, although the mistake was one of law. And then he cites ex parte Chetnik, and I was going to just show you that, what that was about. It's again in our...
Are we to keep this open?
Sorry. Yes, it might be a good idea to keep this open. If we just go to the authorities.
Can I just go back for a moment to that final, to Lord Gough?
Yes.
On page 389. I mean, if we're just thinking for a moment about the always speaking approach to statutory interpretation, and he's saying in the paragraph that begins, I recognise the effect of 32(1)(c) is that the cause of action in a case such as the present may be extended for an indefinite period of time. So in other words, I recognise that this completely defeats the purpose of a limitation statute.
Yes.
I realise this consequence may not have been fully appreciated at the time when the provision was enacted, not that this consequence is the opposite of the intention of Parliament at the time when the provision was enacted, and further, that the recognition of this right may call for legislative reform to provide for some time limit.
Yeah.
So he's accepting that his construction of the Act completely subverts the intention of the statute.
Yes. Yes, that seems to be, yes, that's why I said it might have given you pause for thought as to whether it was correct.
Right, thank you.
Chetnik, it's tab 14 in the new bundle. And
No.
I don't think it's necessary really to go into the facts of this case.
Sorry, Mr. Yost, it's not that.
Oh, that
It's tab 14 in our supplementary bundle of authorities. So,
Yes, thank you.
I think we can go straight to page 874 because this is really a discrete point that's being discussed by Lord Bridge. 874 at the bottom, just above letter H. If you wouldn't mind reading from there to 877, so the next couple of pages, and then the top of page 877, the first paragraph.
The MS 8.
Sorry, it's not in it. It's not in the MS. It's in the. There was a.
Got an MS.
There was a. It was sent subsequently.
So what page are you on in the report?
It's 874. It begins.
Thank you, because there are MS numbers.
Ah, there are, right.
If you're using the you sent it all in a zip file.
Right,
which one
okay.
can,
It's
with an awful lot of other stuff.
It's in this.
It's in there, yeah.
Sorry, I'm getting lost. Anyway, Chetnik.
874.
874 at the bottom. It begins the paragraph. The rule that money paid on a mistake of law is irrecoverable. And then the next two pages, and then the top of 877. This principle has nothing to do with limitation periods. Indeed, it's nothing to do with legal claims at all, I think, as Lord Bridge makes it clear. It's simply an exercise of a jurisdiction of the court over its officers, preventing them from taking what the court regards as a shabby point, that is, mistake of law.
I could conceive that it might give rise to some form of legal claim, but not of a sort of proprietary or private law basis. It's more a public law principle that public officials are expected to behave to standards which go beyond ordinary private persons.
Yes,
And one sees that in public law more generally as well.
And I suppose the clue is in the case title.
Lord Bridge effectively makes that point on page 877, letter D.
Yeah, yes, exactly. And the basis, I think, of the claim is actually section 9 of the General Rate Act. It said that it would be contrary to that, not to repay.
Yeah, sorry.
Yeah.
I mean, I was making the point that
Yes,
if you got to a point where the rating authority was on the point of using the money inappropriately, you could get legal relief. You could get an injunction to stop it doing that. It's just that it would be based on public law principles, not private law principles.
Totally agree with that. Exactly. Yeah. And so going back to what Lord Hope said, what Lord Hope then said after citing that case, he says it refers to a substantial line of authority showing circumstances in which the court would not permit the mistake of law rule to be invoked. These include payments made under an error of law or by a trustee in bankruptcy as an officer of the court. Ex parte James, that's one of the cases that's cited. It's hard to see why in those cases the equitable rule which allows for the postponement of the limitation period should not apply, to the effect that time will not run until the claimant knew of the mistake or wrought with reasonable diligence to have known of it. If the postponement can apply to these examples of a mistake of law, I think it ought to apply to mistakes of law generally. But the answer to that is that it didn't apply to this. The limitation period act simply didn't apply to this.
What's the limitation period for an ex parte James claim, one wonders?
Well, there isn't one, because this is not a claim at law or an equitable claim where it would apply by analogy. It's simply a different, I think, by Lord Sale's point, this is simply a completely different type of jurisdiction. So our submission is none of these points, in fact, support the conclusion that the Act should be construed to include mistakes of law. And then Lord Reid continued, the objection may be made that time may run on for a very long time before a mistake of law could have been discovered with reasonable diligence, especially where a judicial decision is needed to establish a mistake. It may also be said that in some cases a mistake of law may have affected a very large number of transactions, that the potential for uncertainty is very great. I do not think that any concerns which may exist on this ground provide a sound reason for declining to give effect to the section according to its terms. The defence of change of position will be available, and difficulties of proof are likely to increase with the passage of time. I think that the risk of widespread injustice remains to be demonstrated. If the risk is too great, that is a matter for the legislature. And then he goes on, the problem does not arise under the statutory scheme which applies in Scotland. Prescriptive period 5 years under section 6.
I mean, I wonder whether in the context of Always Speaking, the same points that my Lord Reid made about Lord Goss' paragraph at the end of his speech could be made about the points here, because yes. Lord Hope is really saying, well, I recognise that, in effect, the limitation policy is undermined, but just feel that I'm driven there by the language. Yes,
and he hadn't seen these cases, the present cases.
No.
He may have thought, this is not going to be a serious problem. Can I then just address briefly the point that Lord Briggs raised yesterday about the jurisdiction in relation to this point? If your lordships were to conclude that the correct answer was section 32(1)(c) doesn't apply to mistakes of law, is there a jurisdictional problem? And we would say there isn't for two reasons. First of all, the appeal is against the order of the Court of Appeal, which I've shown you. There would be no jurisdictional problem in this court replacing the declaration which exists with a declaration that Section 3121C does not apply to mistakes of law. Secondly, as regards issue 28, in a sense that's not really a jurisdictional point, but issue 28 could simply be answered. This question does not need to be answered, as Section 32(1)(c does not apply to mistakes of law. It must be right that if an issue is stated and the court believes that it doesn't in a sense arise because it's based on a false premise, the court must be able to answer the issue in that way. So unless I can assist you any more on that, on the issue of substance, I was going to turn briefly at the end to more general complaints in relation to things like Henderson and Henderson and new points, etc. It's not entirely clear what the juridical basis is of the respondents' arguments in this, but we presume that it is likely to be based on Henderson and Henderson argument. And the principles have been most recently and authoritatively set out in the Virgin Atlantic case, which I'm sure lordships will be familiar with. It's Authorities 2, tab 23. It begins at MS 769.
You say 769?
769.
Yes, thank you. The leading judgment is given by Lord Sumption. And I think if you turn to page MS 789, page 180 in the report, that's when the discussion starts on res judicata, the general principles. And he distinguishes between the various types of res judicata. And the discussion goes on from there over the pages to page 186, MS 795. You'd like to just cast your eye over these, I'm sure they're familiar principles.
Probably the best distillation, if you reached it, is the bottom of page 184, the quote from Lord Bingham, where he explains what the rationale is of the Henderson abuse. You shouldn't be vexing another litigant with raising the same claims or the same defence that could have been raised in previous proceedings. But the fact it could be raised in previous proceedings is not enough. You have to apply a broad merits-based judgment which takes account of the public and private interests involved and also takes account of all the facts of the case, focusing attention on the crucial question whether in all the circumstances a party is misusing or abusing the process of the court by seeking to raise before it the issue which could have been raised before. That's at the top of page 185. Now, this is not a two-stage, two sets of proceedings case. This is a single set of proceedings case. And this principle has been considered by the Court of Appeal in the context of multi-stage litigation of the same action in a case called TANU, which is in Authorities Bundle 10, tab 118. It's MS 6289. 6289.
Okay.
This, as you can see, was a partnership action.
Oh, I'm sorry, which tab was it?
It's tab 118.
Oh, I beg your pardon, in volume 10.
Authorities 10.
Yeah.
And a question arose as to whether a certain point in the action for an account, partnership action, had been decided by the judge at an earlier stage in the proceedings. And it was held that it hadn't been. And the question then arose, well, was it an abusive process to raise it now under Henderson and Henderson? And it's particularly Lord Justice Dyson and Lady Justice Ardham's judgments that deal with this point. Lord Justice Dyson, which begins, unfortunately his name is at the very bottom of page MS 6295, but his judgment begins at the top, the next page. He says, I agree. I had a few words on my own to explain why the principle of Henderson and Henderson does not apply in the present case. Principle has usually been applied where A litigates with B to judgment and then starts fresh proceedings against B, raising a case which could and should have been raised in the first proceedings. Lord Bingham said in Johnson, the public interest would underlies the principle there should be finality in litigation, that a party should not be vexed twice in the same matter. What is unusual about the present case is that the judge held that the principle applied in relation to separate stages of the same litigation. The judge said that the claimant ought to have raised her contention as to the basis on which the $110,000 was paid, if at all, at the earlier stage when the witnesses were before the court giving evidence. The court could have come to a conclusion on all issues when deciding the question of loan or partnership. And if it had been raised, the further issue of partnership, then on what terms? He added that if the claimant were permitted to raise the point now, this would allow her to open the same subject of litigation in respect to the matter which might have been put forward as part of the subject in contrast, whatever that means, and that was not put forward at the trial. There were no special circumstances to make it appropriate. These excerpts show clearly the judge was applying the precise words used by Sir James Wigram in Henderson and Henderson. But the scope of the rule in Henderson and Henderson was explained and amplified by Lord Bingham in Johnson and Gore Wood. where he said it will rarely be finding of abuse unless the later proceedings involves what the court regards as unjust harassment of the party. It would, however, wrong to hold that because the matter could have been raised in earlier proceedings, it should have been, so as to render the raising of it in later proceedings necessarily abusive. That's too dogmatic an approach. And then Lord Justice Dyson goes on in 34, in my view, the judge applied the rule too rigidly. He failed to adopt the broad merits-based judgment which Lord Bingham refers, and failed to ask the question whether in all the circumstances the claimant was misusing or abusing the process of the court by seeking to raise the issue as to the basis on which £100,000 was paid on the footing as a partnership. It is not enough simply to say the issue could have been raised at the earlier stage, that there are no special circumstances which justify permitting the issue exceptionally to be raised at the later stage. There was no abuse in the present case. It is true that there was no order for the trial of a preliminary issue as to whether there was a partnership at all, but the hearing before Judge Macduff was in fact restricted to this issue. Neither party addressed evidence or argument which was directed specifically to the question of the terms of the partnership. And despite the fact that there are passages in the judgment of the judge in which he appears to be dealing with the basis on which £110,000 was paid, I'm satisfied that he did not in fact decide that issue. It would have been possible to include in the issues to be determined by the judge the question of the basis on which the £110,000 was paid on the footing of partnership. The inclusion of that question would have presented the claimant with forensic difficulties, since the primary case was that there was no partnership at all. Be that as it may, it seems that neither party asked the court to take this course. It was obvious that if the court were to find that the relationship between the parties was one of partnership, and there were to be taking of accounts, a number of issues might arise, which, if not compromised, might necessitate a further hearing and evidence. These might have included the terms of the partnership itself, etc. And then 37, there was this further problem of the decision of Mr. Justice Lloyd. If the claimant ought to have raised before Judge Macduff her contention as to the basis on which the payment was made, then so too ought the second defendant. Why should the claimant be the only party precluded on the taking of the accounts from raising her contention as to the basis on which the payment was made? If the judge is right, then surely the second defendant is in the same difficulty as the claimant. But if that were right, then one could reach the absurd situation that neither party would be allowed to put forward her contention as to the basis on which the payment was made. This merely serves to underline this is not a case of abusive process at all. And then Lady Justice Arden said at paragraph 40, I agree with Mr. Justice Mummery and Lord Justice Dyson. While it may be unusual to apply the principle in Henderson in relation to separate stages of the same litigation, it is not conceptually impossible. The issue for the judge could, for instance, have required him to determine the proportions in which the partners were entitled to share in the surplus assets of the partnership. If the judge had been asked to determine that issue, on the basis that the parties had agreed that the appellant's share of surplus assets should be the proportion which her contributions bore to the total value of the partnership assets, and on the basis that her contributions for this purpose were part only of the sum of £110,000, seems to me that the principle in Henderson would be capable of being invoked if, on the taking of the partnership accounts after judgment, the claimant sought to argue that the balance of that sum also to be taken into account in determining entitlement to surplus assets. However, with hindsight at least, the issues before the judge should have been precisely defined. If they had been so defined, almost certainly the delay and costs that have been fruitlessly spent since his judgment in seeking to establish what was actually decided would have been avoided. That waste of time and cost is highly regrettable. In my judgment, the parties must now set their minds to cooperating with the court to ensure the proceedings are brought to a swift, economical and just conclusion. The difficulty we find in applying all this to this case is, how could it be an abuse to argue issue 28? Issue 28 was an issue that was agreed and set down agreed by the parties, set down by the court, and decided. We are here on appeals from the original decision determining issue 28. And it's difficult to see how it can possibly be an abuse in any sense for this issue to be determined. I was going to take you...
Is there actually a case management order of some kind laying down the order in which issues are to be considered?
Do you mean from the beginning or later on? I mean, there was case management orders before the first stage of proceedings, and I think they included provision for agreeing and setting down a list of issues. And then there were similar orders for the second stage to provide for a list of issues for that stage.
Somewhere we've got a sort of schedule of all this, I suspect, haven't we? But anyway.
Yes, but it's all been done partly by agreement, partly by the court, but under the case management. Yes. I think my point is this is not. It's not a case where we're bringing a new point in the Supreme Court, which hadn't existed before. We're simply arguing issue 28 on a basis that couldn't be argued below. It couldn't be argued. We couldn't argue issue 28 on the basis that DMG and Clement Benson were wrong.
No, but it might be said against you that it could have been argued when this case was in this court before.
Well, at that stage, it couldn't have been argued because it wasn't one of the issues.
Right.
It could have been, if we had anticipated all this in 2007 and set this down as an issue. But the reason that didn't arise at that stage was, this is a point I think I made yesterday, that at that stage there was primary legislation that had removed the extension from section 32(1)(c). So, and all of the litigation, I was going to show you briefly the pleadings, but you will see, when you look at the pleadings before the first stage of litigation, this is the 7th amendment of the particulars of claim, the entire focus was on whether section 107 and 320 were valid. Because if they were valid, none of this arises, because section 32 had been amended to remove, by section 107 had been amended to remove the extension. So at the first stage of litigation, all the focus was on were these provisions valid or not.
Remind me when that was held to be not valid.
It was held to be not valid in the end. Well, section 107 was held not to be valid by this court when they gave judgment. I'm afraid I don't have the date.
Sometime in 2012.
It's 2012.
2012.
Yeah.
Yeah, 2012. So by the time we got to the second stage, we were forced then to admit that as far as BAT was concerned, that the limitation period was extended because 107 and 320 had been declared unlawful. And DMG and Clement Benson, DMG, told us that you had to look at some judicial decision. And as pleaded by BAT, which I'll show you, it was either 2006 or 2001. These were the decisions that were, if that's the correct approach, and therefore on that approach, they were within time, whatever. BAT were within time. So, but the reason that we didn't raise in the first stage, I think, is because everyone was focusing on the question, well, is there an extended limitation period at all? Because on the face of it, Parliament has enacted that there isn't. There was a situation in 2007, 2008 when we were.
Well, you say you couldn't. You say you couldn't below this court have argued that Clement Benson or DMG were wrong. I can understand that. Is there any learning about when a party who or which wishes to make that argument, when they get there or here, has to, as it were, pull that particular rabbit out of their hat and wave it around?
I'm not aware. I haven't found any case which says you have to have done a certain thing. I have seen a case where it was said that all you could have done was seek to amend your pleadings before the judge. That would be refused, inevitably. And you then appeal that to the Court of Appeal. It would be refused there as well. And then you could seek to appeal that to the Supreme Court.
And then the Supreme Court might say, well, let's have a trial first and see what it looks like.
Well, I think
no, you wouldn't, because you couldn't
in
plead.
In a particular case, they had the trial anyway, because the problem is you can't have the trial on the basis of the non-law. So we couldn't plead this point, and we couldn't run the trial on the basis of any viewpoint. Apart from anything else, you wouldn't know exactly what the putative law was. But anyway, you couldn't. A judge couldn't run a trial on the basis that Clement Benson DMG was wrong. So I'm not aware a lot of any case which says, well, you can't raise the point if you haven't mentioned it previously. I'm going to come back to this, but I mean, the possibility of it being raised in the Supreme Court was mentioned below in the Court of Appeal. So it's not as if it hasn't never been mentioned. But there's nothing that says, well, you have to have said something. But in a sense, what you'd be saying is, well, if this case ever got to the Supreme Court, of course, you realise the Supreme Court could change the law. I suppose that's the warning you might have to give. And they might do it even if we don't argue for it.
I mean,
That does happen. That's happened in a number of cases. I was going to come back to that point, actually. Examples of cases where it's been raised by the court themselves.
you're on Cannu. Cannu is just an example that the use of processes can be a flexible concept.
It's exactly. It's confirming that it could, in theory, arise in a multi-part stage litigation, because the main cases all talk about further action, vexing someone by bringing another action where you could have raised a point in a previous action. But I think it's suggesting that it's a pretty unusual circumstance. And it might arise if in the Supreme Court or in the Court of Appeal a party was to seek to raise a point that it could have taken below, and they were saying, well, we ought to be able to raise this. Of course, there is case law on that issue as well, which is the case law on raising a new point on appeal. And I was just going to take you briefly to that. I think the principles are probably well known. But the best case which summarises them all is a case called Notting Hill Finance and Chic, which is Authorities 6, tab 87, MS 2437. This is the judgment. Mr. Justice Snowden was giving the judgment, the lead judgment in the Court of Appeal, and it's beginning on page. It's volume 6, tab 87, and it's MS 2441, page 146 of the report. At the bottom of that page, it begins and it goes on to the whole of the next page, if you might want to read that.
That's the "was Judge Godsmark correct" section.
That's the section, exactly. But the first, down to paragraph 28, he sets out the principles distilled from the authorities. This is all we would submit. This is all presupposing, of course, that the point could have been taken below, which is not this case. But even if it could have been, if it's a pure point of law, permission would normally be given. We would say a fortiori in a case where it couldn't be taken at trial. Unfortunately, I think the consequences of that are inevitably, if there has to be some factual findings, and we don't suggest there is in this case, but if there has to be, then there has to be a remitter in a case where the law is changed in the Supreme Court. Or I'd imagine the same principle would apply if the Court of Appeal changed the law, like overruled previous first instance decisions. Certainly if it's changed in the Supreme Court. Can I then just take you briefly to the pleadings, because there's a point made on the pleadings, just explain how they developed. If you take up Appendix 2, Appendix Part 2, mercifully, I don't need to take you to very many pages of this. The traditional way in which limitation would be dealt with in pleadings would be nothing would have been said about it in the particulars of claim. And the defendant would raise it in the defence, as a defence, and then usually if they wanted to raise some particular limitation point, the claimants would raise it in a reply. That would be the normal process, traditional anyway process. And that's
because limitation isn't a bar to the claim; it's a defence.
It's a defence, exactly. So theoretically, you don't have to mention it in the pleadings. And if you're lucky enough to have a defendant who doesn't believe in limitation periods, then you're fine. In the original pleadings, going back to the first particulars of claim and the first defence, that is what happened. I don't think limitation, as far as I can see, is mentioned at all in the particulars of claim, the first particulars of claim. And the defence, you'll find this on page MS 5108.
And can I just check, when we're looking at these pleadings, these are all in the BAT case?
These are all pleadings in BAT, yes, exactly, yeah. Paragraph 19 of the original defence, any right to restitution, damages, etc., was accrued more than 6 years before the date of the issue of the claim form is barred by the Limitation Act. There was a reply, but I don't think there was any limitation point raised in the reply at that stage. What then happened was, by the time we were reaching the first stage of litigation before the judge, we had got to the 7th amended particulars of claim. And at that stage, limitation was pleaded in the particulars of claim. And you can see that beginning on MS 5175, page 1130 of this bundle. And what you can see is a general statement that they rely on 32(1)(c), paragraph 18, and the consequence of that it runs.
So which page are we on?
Sorry, it's MS 5175, it's page 1130. There's a heading at the top, reliance on section 32(1)(c) of the Limitation Act.
And the date of this is?
Well, what I can tell you is that this was the pleading that was in force before the first stage of litigation. So 2007, it would probably have been 2008.
According to the index, it's 13th of December 2007.
Yeah. It's just before the first hearing, which was in 2008. So you can see a reliance on section 32(1)(c). They say that they discovered their mistakes either when the ECJ gave judgment on 12th December 2006, that's 18A, or alternatively, any earlier than when the ECJ gave its judgment in Hurst, 2001. So they're pleading in the alternative, because it doesn't matter to BAT, as I've said, which of those dates it is. Either of them is fine for them, because they brought their claims in 2003, so they're within time. And then what you see is the next 1, 2, 3, 4, 5, 6. The next 6 pages are taken up with why section 107 doesn't apply, is unlawful. There's a lot of stuff on that. And then the final page is about 320, where that doesn't apply. And the response to that was a denial that they could rely on 32(1)(c), and that's on page MS 5210. On 165, it's paragraph 66 of the amended defence. And it relies on section 107. Saying that section 32 doesn't apply. So the Revenue's position then was that the statutory position is section 32 doesn't apply to you. Their answer to that is yes, it does, because 107 is invalid, has to be disapplied as a matter of community law. So that's how it stood then. But then when we got to the...
So it was never pleaded that it's simply inapplicable to mistakes of law. You just relied on section 107.
Yes. Well, yes, because at that stage, it
you'd already had...
didn't exist.
Well, I mean, very strictly, you deny that they're entitled to rely on section 32(1)(c).
Yes.
Without stating what the basis for that is, although the inference is, because you talk about section 107, that's what you're talking about. Strictly, there's just a denial they can rely on it.
Yes, yeah, that's right. But the position was, our position was 32 simply didn't exist. This was a retrospective change in the law by statute.
But I mean, what's the date of this document?
So, well, this would be...
This is 21st of December 2007.
Yeah. So they were both just before the first set of proceedings.
Yeah.
And you showed us the original defence. Was that simply withdrawn and this amended defence substituted for it?
Yes, this is an amended. Yes, I mean, I think that the position was at this stage you didn't have to strike through things or anything like that. You could simply produce which is, I find terribly confusing, because you then have to look through the whole thing to find out where the amendments are. But that seems to be the position. So you don't have to have any. You amend your defence and you produce the amended defence without actually saying where you've amended it. I think Lord Hamlin, that's been the position for some time. I think the problem probably was there were so many colours that it became impossible to read. I can see that problem. But the opposite problem is you don't know where the amendments are. So all of these are amended documents, but there are no amendments visible on them.
Am I right in thinking that the reference to 6 years before date of issue of the claim form is a reference to the provisions of section 107? Is that what gives you that specific?
Well, what 107 removes section 32, which is the extension, and then you fall back on section 5.
I see.
So section 5 is a 6-year limitation period. If it's not extended by section 32.
But then I'm just slightly confused why the reference is to a cause of action accrued more than 6 years before date of issue of the claim form. Oh, I see. Yes, no, sorry. I'm being slow. Yes, forgive me.
And if I remember correctly, at that stage, as well as arguing that the claim was time-barred by reason of sections 107 and 320, you were also arguing that that the existence of a Woolwich claim, yes, there was no breach of EU law resulting from those provisions because, although they knocked out the extended time bar for the mistake of law-based cause of action, the Woolwich cause of action sufficed to meet the requirements of EU law.
That was part of the argument, absolutely. And the converse of that, which I'm going to come back to, is that the respondents were arguing that Woolwich didn't apply at all to them because there was no demand, they said. They simply paid because the statute told them, not because the revenue demanded it. That argument was rejected by this court as well. But that was part of the debate at that time. So when we then come on to the second set of proceedings before Mr. Justice Henderson, the second trial, which was in 2014.
So just to recap, the 2008 trial deals as preliminary issues with the 107 and 320 points.
Amongst many others.
Yeah,
yes.
amongst others. And those then, some of them then end up in this court in 2012.
Yes.
And then the matter goes back to Mr. Justice Henderson after this court has given its ruling and the ECJ has ruled on the various references that were made to it.
Exactly, yes. The two references, the second and third reference, had come back by the time we were dealing with the second time with Mr. Justice Henderson.
It's at that stage that Mr. Justice Henderson orders you to draw up the list of issues in which issue 28 appears.
Yes.
Which I think he tells us was drawn up in, I think, July of 2014.
Could well have been, yes. Yeah. But also another thing which I think he ordered was that the pleadings should be updated, because at that stage they were a bit out of date, and he felt that if he was going to have a trial, which was going to be fairly lengthy, of the back claim, the back claim ought to be tried on the proper pleadings, so that we know what's an issue. Otherwise, you might be ending up trying to deal with matters which weren't an issue, or not be sure what was an issue. So that's the reason why there was an amendment, and that resulted in what's the 13th amended particulars of claim. The reason there are so many amendments is not because there's a lot of substantive amendments. A lot of these amendments are quite small, adding parties or adding a few words here and there. That's why there are so many amended pleadings. It's not that there were major amendments made 13 times by the claimants. But we have reached the 13th amended particulars of claim by the time we get to the second set of proceedings. And at that stage, the claimants pleaded, this is at page MS 5261, the claimants, and 5262, the claimants pleaded that they were entitled to rely on section 32(1)(c). Their pleading on section 107 has become really quite short. You can see in paragraph 18C, since they've won that point. But they are still pleading, if you look at 18A, they're still pleading the alternative dates, 2006 or 2001.
And this document stated the 5th of June 2013.
Yes, so it's a bit before the second hearing, which was I think was in the summer of 2014. But anyway, it was in anticipation of the subsequent trial. I just point out the fact that they are pleading in the alternative 2006 or 2001. That's because it doesn't matter to BAD, but it did matter to other claimants, and that's why you can't assume that the BAT pleadings can be applied to other claimants in the GLO. There were no group particulars of claims. Some GLOs, I believe they have group particulars, but it was, I think, insofar as it was thought about in this case, it was probably thought it would be too mammoth a task to try and produce group particulars to cover everybody in the GLO and all the different points that were arising. So that was never done. So all we have are particular pleadings for particular claimants, groups. And in the re-amended defence, those paragraphs that we just looked at, 18A to C, were simply admitted. That's page 5287. We would submit that as simply the only course that could have been taken at the time on the state of the law. So as the law stands, even today, these pleadings are correct. If this court were to hold that the law is different, then the Revenue would be asking for permission to amend formally this defence to bring it in line with what your lordships have decided. We wouldn't be changing our admission of paragraph 18C, because that is simply that is the position. You can't rely on 107. So that's certainly correct, whatever you say. If your lordships were to say that there is some, the middle ground I talked about, so if you were to decide that 32.1c does apply to mistakes of law, and there is some kind of factual inquiry that has to be carried out, not about decisions that are made, but about the time at which the claimants could have discovered the mistake, then in the first instance, of course, it's a matter for the claimants to plead that they couldn't have discovered their mistake until at the earliest, June 1997, which is 6 years before they issued their claim forms. So that would have to be their pleaded position, that they, on the law as stated by this court, they could not have discovered their mistake with reasonable diligence before 16th June 1997. And no doubt they have to plead why that was the case, why they couldn't have done so.
How did issue 28 come about as an issue, standing the admission in paragraph 68?
Well, it's an issue because even on the basis of the law stated by DMG, there are claimants who brought their claims after 2007. This was the nine. There's 9 claimants in the GLO, and so if the relevant date on the basis of DMG was 2001, the decision in Hurst, then their claims would be barred beyond 6 years.
And that was the argument, 2001 or 2006?
That was the argument. Well, it was 2001, 2006, or other dates. I think the claimants argued for some other dates beyond 2006, even later. But yes, that was the argument below. Because it, as the Court of Appeal pointed out, it had to be the argument below. It was the only argument that we could have. So that's why the issue was brought in. And looking at it with hindsight, of course, we're all here and arguing about this, but whether you could have dreamed that might happen in 2013, whether you might end up in the Supreme Court, whether they'd be interested in dealing with this point, we were very far away from that. And I don't think Mr. Justice Henderson would have thanked us for raising an issue which didn't arise on the law as it stood at the time, given that there were a lot of issues that he had to determine, which did arise on the law in 2014, and a number of factual issues that he had to resolve. Can I just say something about...
Sorry, I'm so sorry just to pursue this. I'm still a little bit unsure why issue 28 was identified for this trial. The trial before Miss Justice Henderson was of the BAT action, is that right?
It was of the BAT action, but I think the thinking behind it was we hope that we can deal with all issues that haven't been dealt with already in relation to these claims. We're hoping that at the end of this, we'll have the answers to nearly all of the questions, and then we can deal with all the other claims without having further litigation.
Okay.
So that there wasn't just the BAT claim, there was also another test claimant that had to be introduced because there were a few issues that weren't raised in the BAT claim. That's dropped away now because the issues that it was relevant to are not on appeal to this court. GKN, I think it was.
I'm just a little bit confused how people thought what was identified as an issue as between 2001 or 2006, the Hearst decision or the later decision, was going to be fought out by parties with an interest in that difference in the BAT proceedings, because BAT didn't have an interest as between those two, nor, so far as the BAT claim was concerned, did HMRC. So,
yes.
So if the difference mattered, you weren't going to have a trial with two sides with an interest. Well, the HMRC, I suppose, would always have an interest in making it as early as possible.
Remember that we're in a GLO here, and these GLO trials are not just trials of the case. They're attempts to answer GLO issues, so that these issues will then be decided by the court and can then be applied to in the GLO.
So does it come to this, that notwithstanding that BAT didn't itself have an interest, it was accepted that there would be argument about the
yes, there
difference,
was. Issue 28 was included in that. There was argument. Yeah.
Right, and that counsel for BAT would be arguing for the latest date.
Well,
they could, or
you say counsel for BAT. Remember, they're a test claimant for all the claimants in the GLO. Okay. So they're in a sense counsel for all of the.
All right, that's how it was regarded as a real live issue at the trial.
All the funding behind it, I think you can actually see in the GLO is joint funding. I mean, they're all paying.
All right. Yes, thank you.
What I do accept is that you could have had a test claimant that raised the issue sitting there formally as a test claimant. It wouldn't have made any substantive difference to the hearing, but that's probably what could have been done. But
thank you.
So all the pleadings that we're looking at, which the index describes as particulars of claim of a BAT group, are they the only pleadings relevant to the trial, or are there other pleadings that we don't have?
They were yes. I mean, I don't know I can't remember if we looked at you remember the other pleadings, there wouldn't be any defences to them, because those claims had all been stayed. There were the Ford claims, which are still on appeal. They're a kind of discrete thing. There were pleadings to that, I think, probably.
I see.
But none of the 9 people I'm talking about would have had any defences raising limitation. I think you've seen the passage in the Court of Appeal where it said the revenue were indicating they would be raising limitation issues against them. If we hadn't done this, we would have simply had to postpone it until their claims the stay was listed. I think the reason it was brought into this was because, look, we've got this hearing, we've got the vehicle to decide the issue. Rather than postponing it and deciding it in a few years' time, we'll have it decided now. I think that was probably the thinking behind it. If you go back to the first stage, there wasn't really strictly any trial going on there of an actual claim. It was, as I think Mr. Justice Henderson said, really in the nature of deciding legal issues that had been identified as being relevant. And indeed, some of them turned out not to be particularly relevant, as it happened. But that's the way of things. I think you can't always predict in these kind of litigations what's going to be important and what isn't. So I was going to talk a bit about prejudice. The prejudice alleged by BAT, and perhaps on behalf of some of the members of the GLO, is not prejudice of the orthodox sort. The orthodox sort of prejudice would be, this should have been raised at trial, we would have called evidence, the trial would have gone differently. That's what's normally regarded as prejudice for this purpose. The prejudice that they seem to be relying on is they went through the trial at the second stage to establish entitlement to restitution, but this will cut down the amount of restitution they get, even though they were on what they were successful on, because it will cut down the period which they will claim. And that's true, of course, it will. But it will cut it down to claims in the order of, we don't have precise figures, according to the statement of agreed facts, 80 to 130 million pounds for the GLO, somewhere in that region. So even on the basis of this 6-year limitation period, this decision, there's still substantial sums being claimed. And they would have had to go through the trial. They would have to go through the process of which they did go through in order to substantiate that claim, because the issues that had to be decided in the trial would have applied equally to the 6-year period. The issues about computation, etc. As regards costs, they have already obtained cost orders in respect of those hearings. They had 85% of their costs before Mr. Justice Henderson and 95% of their costs before the Court of Appeal. So even if you think cost is relevant, they haven't suffered any substantive prejudice as regards costs. The claimants were happy to go ahead with the 2014 trial, although there were legal issues in play at that trial which could have severely reduced the quantum of their claims, including BAT's claims. First of all, there was the issue of compound or simple interest. Now that's in fact now been decided by a combination of Littlewoods, which I think decided that you weren't entitled to compound interest as a matter of European law, and Prudential, which decided that you weren't entitled to it as a matter of English law. But that was an issue, and it's an issue in the trial, which we now, in FII, it's now accepted what the result is on that. It was never actually argued, I think, in FII, because there was always another case that had decided the point, which was binding on the court, for one reason or another. But anyway, it was an issue there. So they were aware of that. There is a tax credit enrichment argument, which I mentioned. This arises from the fact that when a dividend was paid with ACT, the recipient received a tax credit of significant value. In many cases, they actually got the same amount of money which the company paid in ACT was paid to the shareholder by way of a tax credit in cash. If, as I said before, if it was an exempt fund, they would simply get that money. So overall, the revenue was not gaining anything by the ACT. And the argument is there was no enrichment, or less enrichment, depending on how you look at it, no enrichment of the revenue in that situation. Because although they'd levied unlawful, they'd been paid unlawful ACT, they had to pay out an equal amount to the shareholder. And there is a case called Pirelli, which is on a slightly different point, but which recognises that you can take account of payments to shareholders where you're looking at the restitution of the damages of the subsidiary. That point is in this claim. It's still live. It's one of the points that are before this court in December. In the Court of Appeal, the court rejected the English law arguments that Mr. Justice Henderson had deployed to reject the claim, and reject the defence, but held there was a European law argument which Mr. Aronson had raised in the Court of Appeal, which succeeded. But my point is simply the test claimants were happy to litigate this case, go through trial, knowing that there was a possibility that the bulk of their claim would be wiped out by this defence, if you call it a defence, by this argument about enrichment. Similar points can be made about change of position, actual benefit, etc. arguments which were raised, which have gone away now, but were raised, were in play. So these are not prejudice points that, in the normal sense. They couldn't be prejudice points because, for two reasons, these are pure points of law. And secondly, they're not points that could have been run at trial, as I said before. So it's not possible to say they've been prejudiced by not being able to deal with them previously. Finally, can I just deal with points which the respondents raise in an annex to their written submissions? They have introduced a bundle, which is Appendix 3, which has a number of pieces of material, which I'm sure they're going to take you through. I'm not going to deal with the material in detail now. I may deal with some of it in reply if necessary. However, I would like to make some general comments. I hope you will consider the material with these points in mind. The first point is one I've made already. The first stage of proceedings reached court in 2008 and was being prepared in 2007-8. And at that stage, there was primary legislation, Section 107, which removed the extended limitation period. So that the validity of that legislation was the focus of the litigation at that stage. By defending the primary legislation, which is what the Revenue were doing, Section 107, the Revenue were not undertaking never to raise any argument about the proper construction of Section 32(1)(c) if it hadn't been repealed or amended by 107. Nor were they in any way preventing a court from making a decision on that issue in the future. My second point is that there were findings of fact as to BAT's subjective mistakes. I think this is the point they make. Those were necessary at that stage in the litigation to found liability, even within 6 years. And the reason for that is, as I mentioned a little while ago, at that stage, in the first stage of litigation, the respondents were arguing that they did not have a claim based on Woolwich at all, because there was no demand. So they had to rely on mistake. It was their only claim. So it was necessary, on any view, whatever the position of 32(1)(c), it was necessary for them to show that there had been a mistake subjectively in order to found any claim at all. An obvious general point is that all the stages below were argued on the basis that DMG and Claimant Benson were the law, as it necessarily had to be. We would say it would always have been understood below, at all times, that the position would be different in the Supreme Court if the case ever got there. And this was referred to, not I think at the original trial, but in the Court of Appeal. And this is Appendix 3. This is the Respondents' Appendix. It's at MS 5994. Page 1949. And it begins just at line 6, where I'd said, my lords, the starting point for all this, of course, is DMG. First question, what's the correct legal approach? What did DMG decide? Because if DMG did decide, you could only discover a mistake of law where there was an authoritative legal decision on the point directly on the point. And we'll have to accept there was no authoritative legal decision directly on this point until the decision of the European Court of Justice in the first reference. Lord Justice Underhill, and maybe in respect of some of the issues, the second reference. And I say yes, and beyond that, I mean, this is the problem of mistake of law. And Lord Justice Underhill says yes. Well, I know. Really. This is the real difficulty, and maybe a matter for the Supreme Court in this case, as your Lordship said. It was an issue in Claimants Benson, but your Lordship will know more than I. But it did not appear as though it was a central issue. In fact, it is in many ways a central issue in all these cases, where the Section 1C does apply to mistakes of law. It's a pretty critical issue. It was decided in Claimants Benson. And he says, and in DMG, surely. So I only cite that because it's pretty obvious that if the case does get to the Supreme Court, DMG is not necessarily going to be the law. But nobody suggested, when I said that, nobody stood up and said, no, you can't do that, you can't go to the Supreme Court on this point. We never understood you were able to. It's been suggested that had BAT realised that an appeal might make things worse for them, that they wouldn't have appealed the original decision of Mr. Justice Henderson, that the date was 2001. Well, frankly, that's not a point that they can make at this stage. It was appealed. It really is a litigant saying, had we realised that we might make things worse, we wouldn't have appealed, having got to the higher court and realised that the court was going to decide against them on an even worse basis than had been decided below. In any event, there is the problem with that, which is, well, of course, that would have been throwing the 9 claimants under the bus, those who were affected by the 2001. And they, of course, could have appealed. There is a provision in CPR 19 which allows any member of the GLO to appeal a GLO decision. I think we've dealt with that in our written case. So there'd be nothing to stop them appealing the decision if BAT didn't appeal it. And obviously, if nobody appealed it, then the revenue could have appealed it. We don't know what would have happened. But in any event, it's not really open to BAT now to say, well, had we realised that the Supreme Court might change the law, then we wouldn't have appealed. Simply because it's not expressly anticipated below that points might be taken in the Supreme Court, that is not a bar to the points being taken. That's perfectly obvious from the many cases in which new points have been taken at the instigation of the court itself. And I mentioned some famous examples. One is Pepper and Hart. That's the case which established that you could look at Hansard. Now, in Pepper and Hart, there was a first hearing looking at the matter on conventional grounds, and it was the court themselves who called for a second hearing to debate the question as to whether they could look at Hansard. And it's clear from the judgments in Pepper and Hart, if you read them, that they would have decided the case the opposite way had it not been from the Hansard passages, as a matter of normal construction of the legislation. So it made a huge difference to the result. There was also Sempra. In Sempra, the case had been argued up until the House of Lords simply on the basis there was a right to claim under EU law. It was only after the first hearing in the House of Lords in Sempra that the House of Lords pointed out that this was really a claim based on unjust enrichment. And shouldn't they be looking at it as a matter of unjust enrichment? And that led to a second hearing in the House of Lords, and that led to the decision. It also led to a change in the original decision. The original decision had been based on the interest rates applicable to the claimants, because it had been looked at perhaps rather a non-focused way as being a claim for damages. So they were able to claim back what they would have had to pay in interest for the period that they were out of their money. The House of Lords said, no, that's the wrong approach. If it's a matter of unjust enrichment, you have to look at what the defendants would have paid. How much have they been enriched? And of course, the government pays lower rates of interest than than individual companies. So that resulted in a smaller amount of restitution. And indeed, if you look at, remember Sempra, I think Mr. Rabinovich complained that there had been a concession below. That was the correct approach, and the House of Lords said, well, we're going to allow the revenue to reside off that concession, and we're going to decide it in accordance with the law. A similar thing happened actually in West Deutsche. When the case reached the House of Lords, they rather unexpectedly said that they wanted to hear argument on whether Sinclair and Broom was correctly decided, which I don't think anyone had been expecting. These are only some examples. There are many. I'm sure that all of us could cite examples of this. The court cannot be barred from deciding the case on the basis of what it thinks the law is. All of these arguments might have been arguments for limiting the terms of the issue below, or not having the issue, or something, if they had been raised at first instance. Perhaps, but they weren't. Finally, paragraph 24B of the High Court order, this is a point that claimants make, records the common ground at that stage, which was, if we can just perhaps turn that up, it's in the core volume 2, 140, MS 4185.
Sorry, say that again?
It's core volume 2, 140, MS 4185.
Paragraph 2.
It's
The common ground in yes.
It's 24B. Common ground on any view of the back claimant started the claims when the extended limitation period.
Sorry, Mr. The page again, please.
Sorry.
The MS page, please.
The MS page 4185.
Thank you.
We say simply that that's not an order, part of the order that can be appealed. That's simply a statement of the common ground. The most it has is the force of being an agreement as to what the position is then, which we would say the revenue shouldn't be held to when it transpires that the law was otherwise. Rescission on the basis of common mistake, perhaps. Not sure whether within the limitation period.
I was just going to ask. And whether you couldn't, with reasonable diligence, have discovered it.
No, not until you've... Yeah, those are all my submissions, unless there's anything I can assist in this stage.
Thank you very much, Mr. Hewitt. Ms. Wilson, do you follow? Yes, Mr. Aronson.
I'm told I have to stand between these microphones. As I stand here, not quite the position I was standing in 8 years and 2 days ago, I have this feeling, initially I thought it was déjà vu, but it isn't, it's déjà disparu, if I can put it that way. Because this court has heard interminable, as it seemed to me, argument on the impact of section 32(1)(c) in relation to these appeals. My Lord Reid, then sitting over there, listened to my learned friend Mr. Rabinovich going on for hour after hour after hour to persuade this court that section 32(1)(c) applied to Woolwich claims as well as to claims which were based essentially on mistake. And I'll take you to that. In the course of his very long, detailed and carefully thought through judgment, Lord Walker went through all the cases, Reed, Diplock and all the others, absolute fascinating history of the landed gentry in the 18th and 17th centuries, many of them, amplifying the points which Lord Gough made very briefly in his 1.5 pages at the end of Kleinwort Benson. And I'll be taking you to what happened in this court and the judgment of this court in that case. But before I do that, can I just take you to the order for reference which this court made? It's in Appendix Part 1B at tab 22 and MS 4921.
(4921).
4921. The order for reference came from this court. It wasn't reverted back to the Court of Appeal or Mr. Justice Henderson. It came from this court. And as you'll see, the court ordered that the question set out in Schedule 1 to this order be referred to the Court of Justice of the European Union for a preliminary ruling under Article 267 of the Treaty of the Functioning of the European Union. Schedule 2 to this order setting out the factual and legal background to this reference. And then if we turn over to page 4922, you see the Schedule 1, the questions referred, and the next page, Schedule 2, the annex. So the questions referred, 1, where under the law of a member state a taxpayer can choose between two alternative causes of action in order to claim restitution of taxes levied contrary to Articles 49 and 63, Treaty of the Functioning of the European Union, and one of those causes of actions benefits from a longer limitation period, is it compatible with the principles of effectiveness, legal certainty, and legitimate expectations for that member state to enact legislation curtailing that longer limitation period without notice and retrospectively to the date of the public announcement of the proposed new legislation? So that's the question. Schedule 2, the annex, that's on manuscript page 4923, para 1, this annex sets out the factual and legal background to the reference and a summary of the parties' submissions. So this is an annex prepared to be sent by this court. So it's this court's summary of the factual and legal background to the reference. So if we turn to manuscript page 4924, overleaf, paragraph 6 under the heading background, the claims which form the basis of the litigation.
Hang on just a second, my hard copy is missing these pages.
That's manuscript page 4924. Then para 6, the claims which form the basis of the litigation are common law claims in restitution and damages. The present reference concerns the claims made in restitution. Specifically, this reference concerns claims made in respect of tax payments made more than 6 years before the relevant test claimant, Aegis, issued its proceedings. And then to the next page, 4925, if one drops down to para 10, Section 320 of the Finance Act 2004 was enacted on 24th June 2004. Its essential provisions were as follows. And I'm going to ask you to read Section 320 here. It's very conveniently set out because it's filleted, but one can see the key points. exclusion of extended limitation period in England, Wales and Northern Ireland, and we heard that we didn't have this problem in Scotland. Section 32, this is subsection 1, Section 32(1)(c) of the Limitation Act, extended period for bringing an action in case of mistake, does not apply in relation to a mistake of law relating to a taxation matter under the care and management of the Commissioners of Inland Revenue. So can I just pause there just to deal with one little point my learned friend made right at the beginning yesterday. He said there are other cases which turn on the Section 32(1)(c) point, so your decision here isn't just going to apply to BAT, it's going to apply to the stamp duty, whatever it's, SDLT, stamp duty land tax, reserved, SDRT. It's going to apply to that. Section 320 is still in force, and it would apply to those cases as well to the extent that it applies. Yes, exactly. This subsection has effect in relation to actions brought on or after 8th September 2003. And of course, that was the whole problem, that it was retrospective to the date of the announcement in Parliament, and no one had any chance to do anything about it. And then subsection 2 deals with the circumstances in which time-barred claims can be brought, dealing with new claims in respect of mistakes of the kind mentioned in subsection 1. A new claim shall not be regarded as arising out of the same facts or substantially the same facts if it's brought in respect of a different payment, transaction period or other matter. So you can't amend your pleadings. That will be caught as well. This subsection has effect in relation to claims made on or after 20th November 2003. That's when that point was thought of and announced, again in Parliament or by the Revenue. 6. The provisions of this section apply to any action or claim for relief from the consequences of a mistake of law, whether expressed to be brought on the grounds of mistake or on some other ground, such as unlawful demand or ultra vires act. So it was intended to knock out Woolwich claims as well, just in case Woolwich claims could squeeze under section 32(1)(c). And then look at subsection 7. This section shall be construed as one with the Limitation Act 1980. So it's not a standalone provision, it's saying it's to be construed as one. You might ask why this wasn't introduced into the Limitation Act. The answer for that is that it would have ceased to be a money bill. So you have all these problems with mixed provisions, so the expression is used as one. So there we are, that's set out. Then para 13, and this is, again, if I can just go back to it, this is the legal background set out by this court, para 13. Were it not for section 320 of the Finance Act 2004 and section 107 of the Finance Act 2007, the test claimants would have been entitled to rely upon section 332(1)(c) of the Limitation Act 1980 to provide them with a limitation period sufficient for their Klein-Walk-Benson claims. That's what this court has told the ECJ. That is the decision of this court after a very long, laborious hearing dealing with section 32(1)(c). So I don't think I need to take that any further. But if we now go to look at the what happened in this court, this is in the core volume 2. At tab 14, MS page 4470. And one sees who was in the court.
Which page again?
At 4470. So the composition of the panel of this court at this stage of the litigation was Lord Hope, who of course had been in DMG, Lord Walker, Lord Brown, who had expressed his own views in DMG, Lord Clark, Lord Dyson, Lord Sumption, and Lord Reid, my Lord Reid. If we turn over just one page to 4471, we'll see the counsel for the respondents were Mr. Hewitt, say the old team, Mr. Baldry and Mr. Professor Andrew Burrows. Now, why was Professor Andrew Burrows there? He's not particularly interested in the European law. He's there because this case was dealing with Section 32(1)(c). If we turn to manuscript page 4474, this is in the judgment of Lord Hope, which begins at 4472. At the bottom of the page, the issues. The parties are agreed, paragraph 9, the parties are agreed that the issues in the appeal are best expressed as follows. 1. Could Parliament lawfully curtail, sorry, it's at manuscript page 4475 now. Could Parliament lawfully curtail without notice the extended limitation period under Section 32(1)(c) of the Limitation Act 1980 for the mistake cause of action, Section 320 FA 2004, and cancel claims made using that cause of action for the extended period, Section 107 FA 2007 in particular. And then if one drops below the A, B, and 2, you see just below the middle of the page, to that there must be added the following. Does Section 32(1)(c) of the Limitation Act apply to a claim for a Woolwich restitution remedy, Court of Appeal, Issue 22? We can look at the next page, 4476. And if you see the heading just below the middle, the DMG remedy, Section 320 issue, para 12 at the foot of the page, it follows from the answers given to issues 3 and 4 that this issue must be approached on the basis that a Woolwich claim would have been available had it been brought in time, but it's been excluded by the expiry of the limitation period. The test claimants are left, therefore, with their DMG mistake claim. It has the benefit of the extended limitation period, but the revenues say that it's been excluded by Section 320 FA 2004 and Section 107 2007. We turn over the page, para 16, and I'll read this. On the primary issue, however, like Lord Reid, I agree with Lord Walker. I would take as my starting point the fact that in domestic law, 2 types of restitutionary remedies are available and that the taxpayer is entitled to take advantage of the remedy that's most advantageous to him. A claim for restitution of tax unlawfully demanded under the principle established in Woolwich, and the claim for tax paid under a mistake of law which was recognised in DMG. It is, of course, true that DMG had not yet reached the House of Lords when Section 320 FA 2004 was enacted, but the common law rule that money which had been paid under a mistake of law was not recoverable had already been rejected. It was rejected in Scotland in the Morgan Guarantee Trust case for reasons that were special to Scots law, in South Africa in the Willis-Faber case, but it's also been rejected by the common law in Canada. See the dissenting opinion of Ms. Justice Dixon, with which Chief Justice Laskin agreed in the hydroelectric case. Ms. Justice Dixon's opinion was adopted by La Forestier, with whom Lemaire, Wilson, and Leroux-Dubé agreed on this point in Air Canada and British Columbia. The same result was reached in Australia in David Securities case. Then in Kleinwort-Benson, the House of Lords held that the rule could no longer be maintained and that it should be recognised that there was a general right to recover money paid under a mistake, whether of fact or law. It was contended for the Inland Revenue Commissioners in DMG that the general right of recovery didn't apply in the case of payments made under a mistake of law to the revenue. But this topic had already been the subject of comment by one of the most distinguished and influential scholars on the law of restitution, the late Professor Peter Birks. He declared that unless displaced by statute, causes of action good against private citizens are no less good against public bodies. See his essay in the volume Essays on Restitution, edited by Professor Finn, entitled Restitution from the Executive, a tercentenary footnote to the Bill of Rights at page 174. He also made the point that if in Woolwich the Building Society had made a mistake of fact, would undoubtedly have entitled the society to restitution of the money it paid to the revenue in consequence of its mistake, just as it plainly would have been had the transaction been with a private citizen. The decision of Mr. Justice Park at first instance in DMG, in which he upheld the taxpayer's claim for repayment of tax wrongly paid under a mistake of law with an extended limitation period, should be seen against this background. And then if we turn over the page, para 20. The crucial question, however, is whether the retrospective application of that limitation period to claims based on mistake was in conformity with the principles of equivalence and effectiveness, as explained by the Grand Chamber in its judgment in these proceedings. I accept, of course, that the Woolwich remedy on its own was an effective way of vindicating the Saint-Georges right. But what about the principle of equivalence, which, as Lord Reid points out in para 218, is a complementary requirement? The Woolwich remedy was not the only remedy in domestic law, as it was held in DMG that a taxpayer who wrongly paid tax under a mistake of law is entitled to a restitutionary remedy against the revenue. The theory is that judicial decisions must be taken to declare the law that applies to the case with retrospective effect, whatever the events that gave rise to the claim occurred, whenever the events that gave rise to the claim occurred. So in the events that have happened, the DMG remedy must be taken to have always been available. It is not just a mirror image of the remedy that is afforded under Woolwich. Both remedies lead to the same result, but they are different remedies founded upon different principles, and they're subject to different limitation periods. There may be other differences depending on the facts and circumstances of each case. And then just over the page, and third line of para 21, in fairness, the claimant ought to be free to choose the remedy that best suits his case. So that was the approach of Lord Hope. Lord Walker, whose judgment begins on 4480, dealt, as I say, extensively with the origins of 32(1)(c and the scope of 32(1)(c). If we turn to page 4484, you'll see what the main emphasis of Lord Walker was. This is apparent from para 36. For the appellants, Mr. Aronson took the lead in making submissions on issues of EU law, followed by Mr. Rabinovich on issues of English law. This sequence of argument may have been unavoidable, but it produced the result that the court heard submissions about the attitude of EU law towards national procedures and remedies, which is an important part of this appeal, before hearing submissions about the English remedies themselves. It's more helpful to start with the issues of English law and then assess the impact that EU law has on them. So this judgment proceeds to consider 1, the scope of section 32(1)(c) of the Limitation Act 1980, and 2, the scope of the decision in Woolwich, before addressing the effect of EU law. Nothing could be clearer that Lord Walker was focusing on the scope and application of section 32(1)(c). And if I can just interpolate, if Lord Gough erred in his analysis of what 32(1)(c) covered, then that error is amplified by Lord Walker. He didn't err. He was right. We turn to 4485, para 40. The issue on section 32(1)(c) of the Limitation Act is part of an alternative line of argument by the test claimants, by which the test claimants seek to promote the mistake of law claim and so ensure its protection under EU law. They submit that section 32(1)(c) should be widely construed, contrary to the authority of Phillips, Higgins and Harper, a first instance decision which has, however, stood and been followed for over half a century. They submit that section 32(1)(c) is applicable, regardless of the cause of action, wherever there is a causally relevant mistake. In the words of Mr. Rabinovich, the mistake element doesn't have to be a necessary part of the cause of action, so long as the mistake is materially causal or causally material in producing the circumstances from which relief is sought. So this is an alternative method by which the test claimants seek to saw off the apparent support of the Woolwich branch in order to rely on mistake of law alone. Now, if I look at manuscript page 4486, last sentence of the long paragraph, nevertheless, the section 32(1)(c) point is an important point of law that has been fully argued, and so it should be addressed. And my word, it is addressed. I would invite you, either with the hard copy or with your fingers on the button, to look through the pages. It starts at manuscript page 4486 at paragraph 42. He sets out section 32(1)(c). Paragraph 43 over the page, he talks about the decision of Mr. Justice Hamilton, as he then was, in Baker and Courage. He then goes on to Brooks, Bank and Smith. At page 4484, at paragraph 46, he deals with Philip, Higgins and Harper. Over the page, he deals with Dennis and Shuckburgh at paragraph 49 and goes into more detail in paragraph 52. Over the page again, at paragraph 54, he's dealing with In re Robinson, the decision of Mr. Justice Warrington, and so on. And then the decision of Mr. Justice Romer at paragraph 55 in re Mason, paragraph 56 in re Blake, and then 57 on manuscript page 4492. The last relevant authority is an obiter passage. I emphasize obiter, but it's important. It's obiter. It wasn't the decision, but it was said in the monumental judgment of the Court of Appeal in re Diplock. It was concerned with both personal and proprietary claims against numerous charities. The claims arose in consequence of the executor's calamitous distribution of the testator's valuable residual estate in the mistaken belief that it was held on a valid charitable trust. The executors had by then compromised claims against them personally in relation to a point which was not determinative. Lord Green, Master of the Rolls, delivering the judgment of the court, observed, and then we turn over the page and pick up Lord Green's observation on the fourth line on manuscript page 4493. Fourth line, beyond doubt, it would appear that in the case of an action at common law to recover money paid under a mistake of fact, section 26 would now operate to postpone the running of time. It's true that no such action would lie where the mistake is one of law, but for reasons which we have already given, we do not accept the respondent's contention that the analogous claim in equity will also lie only where the mistake was one of fact. In our judgment, therefore, assuming the analogy, as it must be assumed if section 2 is to apply at all, the action is one for the recovery of money paid away by mistake, albeit by the mistake of other persons and by a mistake of law. And in our judgment on this assumption, it is an action for relief from the consequences of mistake, no less than would be an action at common law to recover money paid away under a mistake of fact. So the very passage which my learned friend alighted on has been read with emphasis, written with emphasis by Lord Walker. And then one carries on over the page at 4494. At para 61, doubts about Philip, Higgins and Harper have been expressed not only by Franks and Edelman, but also in a rather more muted way in Chitty on Contracts, Goff and Jones, and so on. And Professor Burrows, in a note on DMG and the Court of Appeal, is generally supportive of Philip, Higgins and Harper, etc. And then if one turns to 4495, and a key passage, paragraph 62. Having considered the matter with the benefit of much fuller argument than in DMG, I have reached the clear conclusion that Philip, Higgins and Harper was rightly decided, and that we should not seek to develop the law by broadening the interpretation of an action for relief from the consequences of a mistake. My reasons are essentially the same as the Court of Appeals. In summary, as to the statutory language, I agree with Mr. Justice Pearson's view the words have been carefully chosen and are more precise than some formulas such as based or founded on a mistake. That is an imprecise formula, and legal scholars seem to take different views as to whether it would provide a wider or narrower test than the words of the statute. As to history, the authorities are rather short on clear exposition of the relevant principles of equity, but on the whole they provide little support for Mr. Rabinovich's thesis. Their clearest message is the close analogy between the equitable jurisdiction and the common law action to recover money paid under a mistake. Now, I've skim-read a very detailed analysis by Lord Walker of Section 32(1)(c) as it applies to mistake of law. There's not a hint in it that he disagrees.
Sorry, you're saying, I thought it's as it applies to mistake.
As it applies to mistake, yes, but not suggesting for one moment, because we're.
Well, I mean, this is what I was rather interested, because you jumped over, for example, paragraph 54, which talks about a mistake on a fairly arcane point of law, which I thought you might have picked out as an example of a mistake of law specifically.
But it was a fairly arcane point.
Yes.
I mean, these are ridiculously arcane points.
Not necessarily the worst for that.
Yeah.
I mean, I don't know. I mean, because he's not here. The argument is not to distinguish between mistake of fact and mistake of law. It's looking at the question of mistake, and in particular, whether that case, Phillips Higgins case, was right.
Yes, that was the key point.
Yeah.
What is mistake an essential element? Does it have to be an essential element? That was the key point. But in the course of his very detailed analysis, if you actually read the whole passage, some of those cases are really quite funny when you read them. I mean, they're just very strange actions they're dealing with of various people. He's been right the way through it. Not one suggestion that the approach taken in Kleinwort-Benson was wrong. The mistake was a mistake of law. There's no question. The only question was whether that mistake, which was part of the Woolwich claim, was sufficient in the context of a Woolwich claim to benefit from the extended period of 32(1)(c).
But your point from this is it a res judicata point or an abuse point or what?
My point is twofold. This court has done and dusted this. It is res judicata.
Yes, and I see that.
Yes, yeah, it is res judicata, but also it gives very great weight to the opinion in the House of Lords of Lord Gough in Kleinwort-Benson, and it gives great weight to the decision of, I think it was the House of Lords again in DMG.
It's still how I can see the point that the abuse point, the res judicata point is more difficult because if the point wasn't honest, then it can't be res judicata, can it? I mean, if the point
well, it depends how you read the Virgin case, whether it's whatever you call it. I'm referring to this really for two reasons. One, to say we've been through this exhaustively. I sat there listening to it. My Lord Reed sat there listening to it. There are more judgments. I'm going to come to Lord Reed's judgment in due course on this, but Lord Brown commented on, everyone commented on exactly this point. No one suggested for one moment that the reading of Lord Gough as to the application of section 32(1)(c) in the context of mistake of law was wrong. So I pray this in aid also to say that if you have any doubts about whether Lord Gough was right, well, you have to have doubts about whether Lord Walker, Lord Brown, and everyone else who agreed, even Lord Sumption, on this particular point. No, there's total unanimity on this point. My Lord, I see it's 1 o'clock.
Yes, if that's a convenient moment, then we'll adjourn.
We're going to come back to Lord Reed, I think.
Yes, we will come back. We'll go through some of the others first, indeed.